Of you that are here in person and also those watching online. My name is Robert Henneke. I'm the executive director of the Texas Public Policy Foundation, and also am going to moderate today's great discussion with the panelists we have here, talking about transparency and open government, and hopefully giving you all some tools and some resources that you can use as being citizen activists in demanding more transparency that we have from government. I think there's something I'm supposed to announce. No, I'm kidding, because it's like in huge letters written up here. Not to forget that today's event has been accredited for continuing legal education for attorneys. So on the back of the program, I think is the QR code or the CLE number. And so if you're a member of the State Bar of Texas, don't forget to turn that in for your no charge hour of continuing legal education. But as a matter of introduction, what we're here to talk about today is specifically about the Open Records Act and about the Open Records Act in Texas. And, you know, I think to frame the discussion, really from the perspective that we should have, that in all things, really all things, I was going to say many things, but I would say in all things government, you know, sunlight is the best disinfectant. And we as members of the public should not be denied access in nearly all instances to anything that our government is conducting and entering into. I mean, it's a government of the people. We are the people. We deserve to know. But I found it interesting. I've known about this, but I wanted to share with you a little bit about the origin of some of the open government type laws that we have here in Texas. And what we're talking about came and arose from a situation, a scandal in Texas in the early 1970s. And this was the Sharpstown stock fraud scandal. And this was in Texas history, where you had a series of state charges that ended up being leveled against nearly 24 state officials and former state officials. And, you know, before the dust had cleared, the Sharpstown scandal resulted in the incumbent governor being implicated as an unindicted co-conspirator in a bribery case. He lost his bid for re-election. The incumbent Speaker of the House and two of his associated were convicted as felons. Three-term Attorney General lost re-election. The rising up-and-coming Lieutenant Governor's career was politically ended. And half of the legislature was affected in some way, and many of which were voted out of office. And the scandal centered initially on charges that state officials had made this quick turnover on a bank finance stock purchase in return for the passage of legislation that was desired by a banker named Frank Sharp. And so, you know, a lot came out of this through the criminal investigation, but one of the lasting legacies and results of this was the legislation, the government reform legislation that was passed in response to the Sharpstown scandal. So the reason we have state laws today involving state officials having to disclose their sources of income, candidates, campaign finance disclosure, expansion of open meetings requirements for governmental meetings, and disclosures on lobbyists, and also an open records law are legislation that was passed directly in response to the Sharpstown issues. So that, you know, that's the catalyst for why we were here. You know, we take it for granted that we've always had this, but it's really only been a creature of the last 50 years to where there was a codified statutory right in Texas to be able to obtain this information. So we're going to talk more about that with the great panelists that we have here today for our discussion. First of all, I'm very privileged to introduce my two friends, but I'm going to start with Tamara Smith. Tamara is an assistant attorney general for the state of Texas, works in the open records division of the Office of the Attorney General. She's going to explain to you more about what that means. Ms. Smith has been there since 2008. She serves as the coordinator for education and enforcement for the division. and is a double Longhorn, having received both her BA and JD from the University of Texas at Austin. With Tamara is John Riches. John is the Vice President for Litigation and General Counsel at the Goldwater Institute. He litigates in federal and state trial and appellate courts through their Public Interest Litigation Center. You've probably seen and read John, where he's been covered in national media and written in the Wall Street Journal, Bloomberg News, and others. Certainly want to highlight his service to our country as a member of the United States Navy, where he's currently an officer in the U.S. Navy Reserve. And he's Professor Riches. I just found that out. Arizona State University School of Law, and received his bachelor's degree from Boston College and his Juris Doctorate from the University of Arizona. Would y'all help me in welcoming our panelists today? So John, let me turn it to you to kick off. When we're talking about the Open Records Act in this category, what comes to mind? What are we talking about?
I think the first thing that you referred to, right? I think maybe the most accurate thing the Washington Post has reported in the last 20 years is its byline, "Democracy Dies in Darkness." The news certainly has been accurate out of that entity. But the purpose of the act, and it's to open up government operations to the public, who have a right to know what their government is up to, so that the governed can hold their governors accountable. So these are crucial terms or crucial tools for citizens to know exactly what public business is being done and how public dollars are being spent. And for litigators also, they can be very valuable tools. They can be interesting pre-discovery tools for cases against the government. Maybe we'll have a chance to talk a little bit more about that. And then for our work in particular, policy work and public interest litigation, they can be very valuable to know what's going on within the halls of government.
Well, thank you. And just as a part of your introduction, Tamara, so how does your office fit into this? You're one state agency, but we're talking about the entire open records for statewide. So how do you fit into this puzzle?
Yeah, so I think you alluded to sort of the preamble of the act, which is that everything is presumed public if it's adopted by a Texas governmental body. And so our office comes in a couple of roles. One, with training, that's something under the act we're tasked with, and making sure that everyone is educated about the act. The majority of what the attorneys in my division do are rulings, because if a governmental body wants to withhold something, they must ask us in most cases to review that. And so that's another way we come in. And also one of the things that I do is the complaint process, both with costs, talking to people ahead of time, so what we've seen with costs lately, but also the informal complaints and reaching out to governmental bodies and trying to.
So to make sure that we're clear too, when you're talking about complaints, we're not talking about citizens getting into trouble for asking for open records, right?
Yeah, absolutely not. We're talking about a governmental body not meeting its responsibilities under the act.
Okay.
And in multiple different ways, but yeah.
Oh, let it try now.
Oh, is it not on? Hold it on. Okay.
Not an IT person, but that helps.
Didn't even notice.
Well, John, I think we're going to kind of talk about really in the pursuit of this from the disclosure and citizen activist type perspective. So let me start with you on, your thoughts and your advice for this room on how to pursue claims with the act.
Yeah, so I put together a little presentation, which I think will be helpful. No lawyers ever does one of these without the proper Redwell and PowerPoint, right? Plus, you all are getting your CLE credit, so want to make sure that it is properly documented by the authorities in the Texas State Bar. And thanks also, Rob, for having us here and to the event staff. I love coming out to TPPF. It's a great organization that does incredible work. So appreciate that.
And I forgot to mention, just in my excitement to talk about the open records, but today's event, co-hosted not just with Goldwater Institute, but also with the Federalist Society. So the partnership here today. Thank you all for working with us to put on this event.
Yeah, thank our friends at FedSoc as well. So what are the Freedom of Information Acts, which is what Rob was getting at? They're state laws that give citizens access to public information, to the operations of government in two ways, both if official business is being transacted, and if public dollars are being spent. So a lot of people spend a lot of time and energy, and attorneys do this oftentimes in their practice under the federal FOIA, but each state, of course, has its own Public Records Act, and they vary, but generally speaking, they're broader than, more protective of open and transparent government than the federal FOIA. That's true in a couple of different ways. We've talked about this already, and Rob alluded to this in his opening remarks, what their purpose is. There's some pretty good language from some Texas cases, and then from the Texas Attorney General's office, which we put up there. But I like the first one. Its purpose is to grant the people access to information so that they retain control over the instruments they have created. Obviously it's so that citizens have information to hold their governors accountable. They're very useful tools particularly for any attorneys who have been on the plaintiff side of things. And as a public interest litigator, we are often on the plaintiff side, but in a good way, not in like a tort reform kind of way. We're on the plaintiff side representing citizens and taxpayers most often against government entities when they violate constitutional rights. And oftentimes that's an uphill battle, right? Oftentimes there's deference doctrines that are stacked against you, standards of review that might be stacked against you. Well, in the public records context, all of that is flipped, and the requester is really in the driver's seat in a couple ways. First, transparency is the rule and secrecy is the exception. So there's a presumption in the law in favor of disclosure. From the Texas Supreme Court, the act mandates a liberal construction to implement this policy and one favoring a request for information. So what does that mean? In close cases, in close calls, the tie goes to the records requester, not to the government. Additionally, the definition of public record is really, really broad. As I mentioned, it covers essentially anything involving the official transaction of government business or the allocation of public resources. Importantly, if the government agency is going to claim an exemption under the law, so you request public information and they say, well, one of these exemptions applies, which we'll talk about in a minute, the burden of proof is on the agency to show that the exemption actually applies. And really interesting and unique to Texas, they got to go through the Texas AG's office for a first read on that. And that office has done really important work ensuring that the act is properly complied with. And then third, and I don't know if this would be of interest to anyone here, but attorney's fees are available if you win. So that's really nice. So if the agency's withheld production and you have to bring a DEC action or a writ of mandamus to compel production, if you're ultimately successful, then attorney fees can be available. So that's always a nice treat. There are some exemptions under the law. I won't name them all here. They're up there, but they're things that you would probably conceive of as natural sort of exemptions to public disclosure, confidential, proprietary information, privacy information, that sort of thing. Importantly, though, the exemptions are to be narrowly construed. So this is yet another area where the courts have said the law favors the requester, because when the entity is going to claim an exemption, the court has to construe that exemption narrowly. I want to talk very briefly about just procedurally how this works, both for lawyers and for members of the public. The first public records request is really, really important for two reasons. One, a clear request can make the difference between records being immediately produced or there being a delay or an agency claiming onerous fees or an outright denial. So getting that request right is really important. And the initial request serves as essentially exhibit A in the event you got to go and compel production in a DEC action or a writ of mandamus. So you want to make sure it's clear and well crafted. So when the court's looking at it, the court's like, yeah, this person plainly was requesting clearly identified records. I can see it right here. I included these just as some broad highlights of what constitutes an effective request. you always want to include a date, because oftentimes you'll say, records from January 1st, 2022 to the date of this request. And it also serves as the cutoff time for the agency to stop its review for responsive records. The addressee, oftentimes there's a public records custodian within each agency. You could probably find that online. If not, address it to the public records custodian. Cite the relevant part of Texas code. Include a time period. So oftentimes you'll see requesters make the mistake of saying any and all records that have to do with public procurement XYZ. Don't do that, or any email communications to or from council person X. You want to say, look, any communications from this date to that date to kind of narrow the request. And if you need to go broader later, you can. Identify a deadline. Under Texas law, agencies have to produce records promptly. So, I'd give them, say, 10 business days. And by the way, if they don't do it promptly, they got to give you an explanation within 10 days. And then include your contact info for follow-up with the agency. So the substance of the request, when you're actually putting the body of it, that's really, really the most important part and the sort of art aspect of this rather than just the legal component. Just a few obvious pointers. Only seek information that's allowed under the law. So if you know something is going to be private or proprietary, don't put it in the request. It's just going to create problems for you down the road. Avoid requesting exempted information if it's really clear that it's exempted. But again, because the burden of proof is on the government and because exemptions must be narrowly construed, if it's a close case, go ahead and request it. But if you know it's going to be exempt, don't waste your time doing that. And then identify the right people to send it to. Consider the scope. I briefly alluded to this. So this sort of depends on whether you know the record exists or whether you're seeking information about a particular topic. If you know the record exists, ask for the record, right? If you know that you're looking for some government contract between the city of Austin and its many cronies, then just say, I'm looking for the collective bargaining agreement between the city of Austin and such union from this and this state range. Identify it precisely. If you don't know whether it exists, try to draft it with enough precision so that the records custodian knows what you're asking for. So again, not any and all emails from this person to that person, maybe any and all emails from this state range that include the phrases, contract XYZ or whatever. Include specific phrases if you're looking for that sort of stuff with as much precision as possible. This is an important point that's often lost on people, particularly like public interest litigators who don't mind rushing to court. But consider discussing the request with the records custodian, because oftentimes you could kind of work out what you're looking for. I used to be in the federal government when I was on active duty. I used to be the FOIA person that got the last review of this stuff. And I always appreciated it when the requester would reach out and say, here's really what I'm looking for. Maybe I didn't draft it quite the right way. And we can all be, we can all have those shortcomings as well. So as the requester, I think you should always maybe think about talking to the custodian. But if you do that, and then you narrow the request or change the request in some way, make sure to get it in writing. So follow up with email. Hey, today we had a discussion and I decided I'm only going to seek 3 months of records rather than the original 1 year that I had in my request, so that if you have to end up compelling production, you have an administrative record. I always submit the request in writing. Each agency handles this differently. Some of them have online portals, which you can use, which is fine. But I think even if you do an internet submission, I would still draft a letter, put it on your firm's letterhead, and send that by email to the records custodian. I think it's just cleaner and it looks better as Exhibit A if you got to compel production. And then you have it right there on paper, and there's not some weird software system that's messing with it. And then always seek confirmation that it was received by the public entity. The time frame under Texas law is promptly or within 10 days if they can't do it promptly. And if they claim an exemption, they got to go through the AG's office, which is great. And hopefully we'll have a chance to talk quite a bit about that. When you get the records response back, review it really carefully for a couple of reasons. Ensure that they actually are providing responsive records. And there'll be all sorts of strange things in there. I got a case I'm litigating in New York, or actually another attorney we're working with is lead on it. But we requested some school records and some emails between a school district and a private entity that was doing some CRT and other sorts of training for the school. And in the, we asked for all, email records over a certain period of time. And in the responsive records they produced, they said, yeah, and as I mentioned in my email from a week ago, such and such. But of course, the email from a week ago wasn't included in the production that they provided us. So look out for things like that. And when you get the responsive records, ensure that everything you asked for was provided, and see if there's other things in there that could lead to information that should have been provided. If they claim no responsive records, is that true? I mean, if you know responsive records exist and they're claiming no responsive records, that's important. And if they claim an exemption, make sure that it actually applies, and make sure you're aware of the timelines. In Texas, there's some pretty tight timelines involved, particularly with AG complaint processes as well. Can the government charge fees under certain circumstances? Essentially, if it's less than 50 pages and won't take more than 5 hours, they shouldn't be able to charge fees for labor, which is the big cost. They can charge fees for copies of records. It's like 10 cents a page or whatever the AG says it is. I think that's the rate right now. And you can seek a waiver as well if it's in the public interest. So if you're doing something that's on an issue of public concern, you can seek a waiver from the agency. If you need help, if you end up getting a request denied, you're looking for assistance, our organization, the Goldwater Institute, started a nationwide state-based public records project. We have resources for the public about how to submit public records requests in every state at openmygovernment.org. And we have a template there, as well as an explainer guide that sort of walks the public through how to do this in their own state. And then, of course, we have in-house litigators. We work with our partners like TPPF and other public interest groups, other pro bono lawyers, that if a request is denied and we need to compel production, we have attorneys to do that. And I know TPPF has a open government component to its practice as well, if that happens to you here in Texas. All right. And then we'll talk a little bit about remedy.
Yeah, so thank you, John. And one thing I want to add to that, and that was a great presentation. I would add on that is when you're asking it, ask for records electronically, because it's a convenience thing, but it's also a cost thing. My understanding in Texas, and Tamara can correct me, but a governmental entity can charge you I think $1 a page, but they can only charge you, or 10 cents a page, 10 cents, but they can only charge you $1 per CD-ROM. So if I ask for 1,000 pages, it's gonna, whatever, I can't do math. But if I ask for 1,000 pages electronically, then the most that they should be able to charge you is the $1 if the records are available electronically there. So that's a way to avoid costs and avoid some of the issues. But I'm a little confused now after John's great presentation, because with everyone here in the public following all the steps that he laid out, I just assumed the governmental entity just like, here you go, right? And that's always happens. So you must not have much to do. Your office must be very slow and boring. Because I'm just assuming that all of these governmental agencies and entities in Texas are just like, here you go, right? Is that how it works?
That is not how it always works. But I have some examples if I can give my comment. I don't have a PowerPoint presentation, but definitely wrote some examples and things I didn't want everyone to miss today. So I will start not at the remedies quite yet, not quite at the role of my office yet, but in talking to John beforehand, I wanted to give a few examples of requests, just more specifically things, most of these that I've actually seen come through my office, and the good and bad and how to do that. So as he mentioned, how a request is worded matters. It doesn't mean you can't request stuff, right? It doesn't mean, as Rob's intro, that everything's not open, but just getting over some of those hurdles. So as John mentioned, being specific can help. And I think the other thing that's important with that is it doesn't prevent you from making a second request, right? So one of the examples that I see done a lot there is maybe requesting a call list for all the reports for a specific address, and then later requesting only the reports you want, and not all the reports where you may get a very broad answer. The other example, before we get to costs, that I like to use is a good example that has been alluded to twice now of talking to the governmental body. And when I'm training governmental bodies specifically, I remind them that they know their records, that the citizens don't, right? That calling something by a specific report is not necessarily something who is not in that office on a daily basis knows, right? So talking to the governmental body, if you have that good relationship, can definitely help up front. An example that I saw of this, that was an actual complaint we got, was a citizen was upset with a specific sheriff's actions. It was a smaller county, so they asked for everything with that the sheriff had signed, which, you know, during a specific period of time seemed like, okay, I just want what he was doing those days. But because it was a smaller county, that sheriff signed all of the leave requests, everything that came through there, right? So it ended up being a large request that came through. We handled under the cost, sort of talked to both parties, but up front, that communication can matter. And so the other thing with requests and sort of preventing a delay is, while you are allowed to make anonymous requests under the Public Information Act, if it's something that you're requesting where you believe you have a specific right of access to it because it pertains to you, or there's a specific statutory right of access to something that otherwise would be confidential, I think it's always good to note that up front. You know, we remind the governmental bodies too, if there's an attorney, do they represent someone? Are we requesting a ruling for something that they have a right of access to? How a request and when a request is made can matter. I know in the slides that were just up, we sort of mentioned that online portal. Something we get complaints about, and the citizens are correct, an agency can have that online portal. I think it's a great tool. As Rob said, some of the electronic records, providing them that way may be faster, cheaper. However, they can't require that, right? The statute, the legislature's amended that they can have a designated email, a designated mailing, a designated, you know, in person, but they can't require that portal. It's something they can do in addition. If they have those designations, meaning they're requiring you as a citizen to go to a specific address or mail it to a specific address. For example, my office has multiple locations, and that's something that they are required to have posted. They're required to have that on a sign, and it should, at a bare minimum, be on their website if they have their own website. So keep that in mind, and that's something we definitely have called and educated governmental bodies and reminded them of their obligations there. And the other sort of specific request I wanted to call out here, if you are dealing with law enforcement records and body cam, just know that's one of the few cases where your request is required to have specific information. And so that could delay it if that information is not in there. Excuse me. So complaints and remedies under the Public Information Act. That's where we really get into what I do. And the Office of the Attorney General, as I mentioned in our first question, is responsible for that uniform application of the act. And we do that in a number of ways, point out what we can do, what we can't do, and who the proper people are. So informal complaints. When I mentioned that, that is a complaint from you as the citizen to us that an agency is not following the Public Information Act, that they're delaying release, that they're not requesting a ruling, right? That's something we handle. We will typically reach out to the governmental body, you know, unless we see it and explain it to you, the process. The other type of complaint that we handle directly in my division is cost complaints. So we've mentioned costs a couple of times today. In general, governmental bodies can charge for records, but those charges are limited by our rules, and they're limited to certain things. In those cases, if you believe an agency is overcharging, that comes to our office. You do have, as a citizen, 10 business days. It's from the date that you knew of the overcharges, and we do need a copy of your request and a copy of anything you received with the charges. So we try to keep it pretty straightforward, but we do need those things. And we do have a portal currently for that. There is also a sort of formal complaint under the Act pursuant to 552-3215. In most cases, if it's not against a state agency or the district attorney, that would have to go through your local prosecutor first. And then if they decline to take action or don't respond, which they're required to by statute there, that can come to us and gets handled by our criminal division. Some things we can't handle, just again, for purposes of delay, is we get open meetings complaints filed through our portal. Open meetings is handled by their local prosecutors. Those don't come to us. It's not something we have authority for there. Also, criminal complaints. One of the big ones we see there in terms of coming through our complaint is you made a request for records. the agency said they don't have the records because they improperly destroyed them. So we can't do anything about, like, the records aren't there. There's not really legal action I can take to get them released. However, there is a criminal penalty for improperly destroying records outside of that. So that's something also for that local prosecutor. We've mentioned also education records today. If it's an issue of FERPA and if FERPA applies, that's also something that would have to go through the Department of Education, since that is that federal statute. So now, last couple things, just wanted to briefly speak a little more about costs and tell you sort of the numbers of our office right now. With costs, the most common thing we see in general, the general rule for copies is that an agency can charge for materials, labor, and overhead. I will tell you, when we are getting those cost complaints, 90% of the time or more, what we're really discussing is if they are properly charging labor, because it is not that an agency can charge labor for anything they're doing related to your request. For example, I think the thing we pour out for a governmental body most often is for review. If they tell me that they're charging you $1,000 and the time that they're charging for is to review those records to figure out if they want to raise exceptions, that is not an allowable charge under the Public Information Act. They are allowed to charge to redact confidential information, which going back is maybe why your request matters and excluding certain things, but they're not allowed to pass that on to you to just review them. And so that's one of those most common complaints that we're seeing there. The other common thing I'm seeing lately is, I'm glad Rob mentioned the not printing things, but they're printing it and they don't need to, right? Sort of upping that charge on you, or converting it and they don't need to. It's not that they necessarily can't, but those are not things they can pass on to the requester. And then finally, with the cost, if their estimate is missing some of the required elements, that's another thing where we wouldn't let them withdraw the request and other items. So finally, I just wanted to end before we get into questions and what everyone wants to know, just with the numbers of my division. And those attorneys that I mentioned that are handling the rulings, we just sort of calculated our fiscal year for last year. Last year, my division issued 39,633 open records determinations. So those are all of those things that are coming to us to review. And with that, we received little over 62,000 pieces of mail. So that's what the vast majority of those attorneys in my division are doing. With what I do, up to this point in the year, so through September is when I had stats, we've received 9,800 calls to our hotline. That is available, citizens, public. We're there to answer those questions on the front end for you. We received over 900 of those informal complaints, received 400 calls just about costs alone, and 186 cost complaints. So you're not alone with those issues. We are here for you, like I said, both hotline beforehand and with those complaints. And with that, turn it back to Rob.
Good, come back and join us. Thank you. Thank you for that overview. So I think, in the discussion we're going to have, and then I will turn it over to the audience questions, but, let's get to some of the brass tacks of tactics and also issues to avoid. And I'll set the table. John, I'm going to ask you in a second if you can give us an actual example of how you use this and how it provides a useful tool. But I'll do that first by, one way that you can use the Open Records Act is really to lock a governmental agency into their position. And the example of this that I'll give is we at TPPF several years ago were looking at the city of Austin's new ordinance that was involving vacation rentals and short-term rentals. And the basis that was given in city council and the public was, this is a huge public issue. There's all these like Animal House fraternity parties and all of these violations and, drunk people falling in the street and just these neighborhoods that are being terrorized by these vacation rentals that are really consuming our city and turning Austin, into, downtown Miami or whatever. Just biggest exaggeration I can make, picture that for yourself. So we represented a coalition of short-term rental owners, but we hadn't done anything yet. And so to kind of set things up and to really examine what this issue was, we sent an open records request to the city of Austin that said, we want every complaint that's ever been made against a vacation rental in Austin since you first started licensing them. Everything. And it only about 4 years of data because Austin only started regulating vacation rentals in 2012, and this was like 2016. And so we got it. We had to go back and forth several times. You know, it turned out that there was about 3,500 records. But we found was that in the data, everything that we got from the city of Austin, in terms of like loud parties, noise complaints, trash, illegal parking, like each of those categories only had about like 100 violations or 100 complaints made, not even like violations, but just like in 4 years, only 100 people had complained about a loud party at a vacation rental. So we use that data in our claims in the lawsuit, but not only that, it locked in the city of Austin's position as far as them after the fact trying to like, you know, justify things or change the perspective, because we already had all the information. We didn't have to go get it in discovery and go through a discovery fight. You know, we had their records and we had that, and it showed us ahead of time, here were the facts that the other side, it was their facts, but they didn't even know about it. So, you know, when you're dealing with governmental entities and you know that there's something you're going to want to do, this can set up a potential action, because then you have locked them in with their own information and set that record moving forward. So John, what's another example of how y'all have used this in kind of practical application of the Open Records Act?
Sure. I'll give two, a litigation and then a policy one. So, you know, for the litigators, if you ever have a case where the government's going to be on the other side of the V, these are really valuable tools pre-litigation. So we do a lot of taxpayer actions. The great state of Texas, for example, has taxpayer standing, where any taxpayer can sue to enjoin the unlawful expenditure of taxpayer funds. The greater state of Arizona also has taxpayer standing. So I'm kidding. If I didn't live in Arizona, I would live here in Texas. It's a wonderful place. We also have taxpayer standing. So we do a lot of that work in Arizona as well. And so, for example, if you know, the city of Austin is going to give a subsidy to some private entity, whatever the form, you can get through the Public Records Act records of the communications with that entity, any contracts with that entity, any draft contracts with that entity before you ever even sit down to draft the complaint. And that can be really valuable in terms of how you frame your case. And if you're moving for a PI, for example, for a preliminary injunction or a TRO, you'll have information and records available pre-action, which I think can be really, really valuable. And then the second way, and this kind of goes more to citizen engagement. So Goldwater, like TPPF, is also a policy shop. So we were set up in 1988 as just basically a think tank. And then in 2007, Clint Bolick came on board. It's now Justice Bolick on the Arizona Supreme Court, and he set up our public interest litigation component. So we do both. We do public interest litigation and policy. And one of the things we're working on right now is what we call academic transparency, which requires public school districts, it's a pretty novel concept, requires public school districts to just post the information that they're going to teach in class on an online accessible portal, right? So that parents can look at it and decide whether this is where they want to send their students.
That's completely unreasonable.
Why
would you want to know what your kid's being taught, John?
You would be surprised at how unreasonable the public school establishment thinks that is in the state of Arizona and elsewhere. So some of what we're getting is, well, I mean, hey, look, like, we're not teaching things that are controversial. We're not teaching CRT or this other type of study. That's one of the responses. So you don't need to worry about that. This stuff is really, really hard to gather. So you can do a public records request and you submit the request and, well, look, turns out they actually are teaching that. And oh, by the way, you do a public records request and they're like, God, we don't have lesson plans for K to 12. To which the response is, well, that's unusual.
Yeah.
Maybe that should be available. Or the other side, well, if you already have it, what's so hard about then sharing that with the public so that, so that parents and students can make informed decisions about the education of their children. So that's sort of, that sort of thing. And I can talk about a whole bunch of other examples, but those are two kind of hot ones.
So Tamara, a little bit different question, but say the customer's always right, but citizens aren't always right. I mean, there are limitations on this. And look, I mean, in your role, you evaluate these requests, but I wanted to ask you for any suggestions or things you've seen where a complaint's been filed or where there's been an ORD that's been submitted, open records determination by a governmental entity, and they've got a point, and the citizens or the attorney or whoever's mad about it, but they didn't do it right, or they're asking for something that's out of bounds, or not pursuing it in a way that they're entitled to. Can you think of any examples that you've seen that where maybe it's out of bounds, and maybe ideas of how to correct that in reshaping your request to avoid that in the first place?
Yeah, so a couple things. I think the first one that comes to mind that can be corrected and is a timing thing is when you make a request under the Public Information Act, it's as if it's a snapshot on that day, right? For any exceptions that the governmental body is going to raise, it's a snapshot. It's that day you made the request and that they received it. So a couple things we get as complaints are, if I'm requesting something today, that the report wasn't finalized until tomorrow, right? An autopsy report, the city council report, where the city's answer to me that there wasn't information in existence at the time of my request is correct, even if they are answering that at a time where the report has now been made. Don't get me wrong, some of them are good at customer service and will let you know and provide it, but that's something that could be corrected. The same with in litigation exception is an exception that an agency can raise. And we look at a snapshot of did they anticipate or were they involved in litigation the day the request was made. So I think the example here, I think both of you actually talking about getting the information before they could argue that litigation was pending or anticipated, fixes that problem there. And another one, with being specific to those records is really making sure that you're making it to the correct entity. And a big one we see is with counties. So counties in Texas, city make it to the city person for any city department. In counties, each separately elected county official is their own public information officer. So even if you're requesting it from the county clerk, but it's the sheriff's records, that may not be a proper request. And that's something we're willing to walk people through and help. But those two sort of things, that timing and making sure you're making it to the right person, are two easy things to fix on the front end.
And I would add to that too, two common mistakes that I've seen to just keep in mind is, one, you can't use the Open Records Act to demand that the government create information that doesn't exist, and related to that, you can't use the Open Records Act to make them just answer questions. So if it's a document, you've got to ask for the document, but you just can't say, Open Records Act to the city council, explain to me why you tax me too much or something. I mean, I guess if there's a document that is like the city white paper on why we have onerous property taxes, maybe. But the point is that you got to be thinking about where that record exists that you want to use, not that this is just a tool to make them create information or provide an explanation for things of what you see. Yeah.
I'm going to add on to that first part a little bit. And what we have seen recently, sort of in some of the costings and some of the complaints, going to your first point about you can't make them create information that doesn't exist. 100% true. But where we've had to correct governmental bodies or educate them is, if I have a database, right, and Rob's asking for something from that database, they can't just tell him, well, that exact report doesn't, right, we didn't already run that report. They have that data. We would generally require them to provide some of that.
Mm-hmm.
It's something we're getting from them recently. I haven't already run it.
So John, and both of y'all, as my last question before we go to the questions from the audience and online, that you can submit your questions via, I guess, our Facebook and YouTube channels. We think about emails, but what are the things you can ask for that can be instructive in, finding out what your government is doing? And I'll give an example to start. One category that nearly always is going to be informative and subject to disclosure are payment records. You can learn a lot about what government is doing just by the transfer of money. And it can be a great investigative tool to just show where that money is going, either how it's being spent in the budget or who it's being paid to as far as outside parties. So asking for records of payment or check registers or something like that can tell you a story just about the flow of money. Any other categories come to mind that are kind of not your traditional, like email records or something that come up?
Studies, reports, if the Phoenix Suns are thinking about subsidizing some private entity to build a stadium, there's going to be a RFP that probably went out to conduct a study on, the return on investment, et cetera. So I think those are probably good ones. Communications in whatever form, people always ask for emails, but I'd ask for communications in whatever form, because that includes text messages. And if a public official has a text, even if it's on their personal device, if it pertains to the public's business, it's a public record. So if you're asking for communications, I do them for whatever form. And payments are, as Rob said, that's crucially important. Both invoices that the public entity has received and expenditures that it's made. We're looking at this issue right now where local governments, even though they have, internal staff of 40, 50 city attorneys, they'll then, if they're sued, will go hire outside counsel at, an enormous cost, which seems to be a taxpayer sort of protection issue, but they maintain invoices, of course, from all of those outside entities, and they have expenditures. So those are really crucially important, like Rob said.
What do you think?
I was going to say, I think both of the things you guys mentioned first, payment and then final reports, are both found in a section that's a good place to start for that. And that's 552.022 is a list of things that our legislature has essentially said super public. They're things that they can only raise confidentiality provisions for. They can't raise some of these discretionary exceptions like the litigation exception. And both of those completed reports and many financial records are listed in there. So I think that's a good place to look for that.
Great. Well, thank you. Well, let's go to questions from the audience. And if you'll wait for the microphone to get to you so we can catch this for those watching online. Sir, let me start with you.
Thank you for your time. My question's for Tamara. This might be an obvious answer. Maybe the answer is, of course, it's the government trying to throw a wrench in the works. But to what extent do you think that they are assigning costs tactically to make it prohibitively expensive for the public to find out versus those organizations are strained for resources? Thank you.
Yeah, I will say, and I sort of mentioned this in talking to some people ahead of time, I've seen both. I get calls daily with those 400 cost calls from both sides, right? The governmental body telling me we're a tiny agency and this actually is going to take us 2 weeks to go over there. That really is where we come in, right? To look at them. I would say those things that I mentioned with the reviewing them that we can cut down real easy. And that's also where excluding some confidential information. If you can exclude it and they don't have to redact it necessarily, that's one thing. That's where with communications, I think we see the most redactions and costs because email addresses of members of the public are confidential and then attorney-client privilege. So with those requests for emails between counsel, there actually may be a good deal of redactions involved.
And I'll just add one point, because Tamara has to be more diplomatic than I do, of course. But it's actually really nice the AG has this role because they can hold government actors accountable, and that's unique to Texas, and that's a huge benefit. But we're seeing it throughout the country. I'm representing a woman in Rhode Island who requested information about what her kindergartner was going to learn, and they sent her a bill for $74,000. And we're seeing it all throughout the country. And then, oh, by the way, the public entity, the school district, thought she had submitted too many public records requests, so they threatened to sue her to stop her from doing that. They didn't carry through on that threat, but the local union did, and actually named her as a defendant in a case to try and stop the public records request. So we have an anti-SLAPP motion pending on that one. But it does happen. But I will say it totally depends. Like some of these entities are acting in good faith, and it really does take a lot of time, and they really do have limited resources. But if you suspect that, you know, they're using fees to try and hide the ball, reach out.
Yeah, go ahead.
I was just going to say, that's one of those, you know, they mentioned they don't have to answer your questions. They do have to answer mine. If I get a cost complaint by statute, I'm allowed to ask them questions and they have to answer. And those questions are generally, they seem pretty innocuous, right? Just how did you come up with this number? And sometimes that can provide the requesters ways to narrow it if they really are being honest in that point.
So I have two online questions. We'll come back to the audience. Tamara, one for you real quick. You know, from the actual impact on these governmental entities, especially the local governmental entities, the question from online wanted to know how onerous, how is it really? How much work is it really for them responding to these requests? And, you know, is it a burden, or is it just something that's being exaggerated by the governmental entities and shouldn't be all that consuming?
I think the thing to consider there, when I'm giving examples here, right, I'm giving you the worst of the worst, right? On a daily basis, the calls we are getting are agencies who have someone assigned to do it and are doing it correctly. And, you know, we're coming up with a little issue. I would say generally it's not. Like that impression that we're giving you where it gets to my office is not the vast majority of cases, right? So that's important to keep in mind. And even with those 39,000 rulings we did, you know, I promise you there were multiples of that in terms of requests they actually received and were releasing. And most people are trying to do it correctly.
So John, the question back kind of specific in the education context. So this was a question in Texas, we have the TEKS, which are the kind of the statewide education standards that everything in public education has to be taught pursuant to those TEKS. But they're kind of broad, they're categorical. And the question from online wanted your advice on beyond that, when you're trying to dig into what's happening in the school, what are examples of what you need to be asking for to kind of get behind that and peel back several layers of the onion to have a better clarity as to what's happening in your child's classroom or your school in general and so forth?
It's a great question. I think a lot of parents or citizens that are just trying to figure out what their kids are going to learn will say, hey, give me the syllabus, you know, from this particular year or whatever. But it's important to specifically ask for things like lesson plans. So daily lesson plans for the academic school year in this particular subject, or materials that were distributed to the students. Or if the school district uses like an online platform like Canvas or something, any materials that were posted to Canvas for this subject during this school year. So be real specific about that. And lesson plans is the key one, because they should maintain all of that stuff and they should provide it. And it goes much beyond just, you know, the syllabus. And ask for specific teachers or subjects if you have concerns there. Start narrow and broaden out. Because you kind of see what the universe looks like, and if you want to tailor your request based on what you receive, I think that's often helpful.
All right. Any other questions here? Yes, sir. And I'll come to you next.
My question relates to education in a way too. With FERPA, you mentioned FERPA. To what extent in our dual federalism world are the two sides pointing and saying you got to talk with the other folks? The feds saying we're protecting this information, especially at universities, and the state saying, oh, that's a federal matter, and the Fed saying it's a state matter.
So there is one part of that that's very clear, and that's law enforcement. You know, anytime they've tried to claim FERPA for law enforcement records, we say, no, those are not FERPA, right? And
I'm thinking the money.
Yeah. So, you know, FERPA is defined as education records. There's some things that are very clear. We will ask them about that, but they've issued a letter to us telling us we are not allowed to make that determination. So it's left up in most cases to that educational institution. And like I said, unless it's a very clear category that's been carved out, we're not allowed to get involved in that.
And I wouldn't take their word for it, obviously. And FERPA
Yeah,
only
we
just,
just-
yeah, of course. FERPA just covers a discrete category of student records, and within that, only certain records. So, make sure that FERPA actually applies. And by the way, we've seen this, we're actually looking at this recently, where the school district claimed FERPA when a parent made the request for the student's records, which does not apply. It's like, a client, lawyer telling them attorney-client applies, look real precisely at where they're claiming FERPA, but because oftentimes it won't. And again, the state public records laws are broad.
Hi, so this question I think is for John about texts and Signal. So some sort of encrypted messages. And I assume like if you ask a council member, I want your texts that are related to work, it's on their private phone. Does someone look at their private phone or you just have to trust them? And what do you do when they don't want to give you that? If you say communications, does it include encrypted text like Signal? Like how does that work and what are their obligations?
You might be better
I
to
was gonna
cover
say,
that.
I
Yeah.
could actually cover that.
Please.
This was actually something covered by our legislature during the last session. I don't know if it will be again, but it's something that was addressed. It wasn't a huge change in the law overall. We've always said that those were public, right? That they relate to public business. They did add some language and calling the individual council member, the individual official or employee, a temporary custodian of those records, making it very clear that, right, that the agency itself doesn't have custody, only I have custody, right? So I am a temporary custodian of that records. And in terms of enforcement, right, they listed some language in there saying that there could be disciplinary action for failing to turn them over. But yes, I always, when I'm speaking to agencies themselves, tell them to consider that on the front end, right? That is not a discussion you want to be having afterwards. Years ago at this point, we saw a city council who got them all iPads, didn't realize until after the fact that the iMessages were different than the text messages and they weren't capturing those, right? So it's something I'm always like, consider that on the front end. But yes, the legislature did address that a little bit last session, making those the temporary custodians.
So as a matter of practice point though, Tamara, in Texas, if you're going to try to get communications involving, a governmental official, let's say the mayor of Austin,
Absolutely.
are you saying that we now need to send the records addressed to the city of Austin and also the mayor?
No, sorry if I was confusing about that. You are still, as a citizen, making it to the governmental body. The burden is then on the governmental body to make sure they're getting those records from wherever they exist, their own email, or they need to go ask the mayor if they know that he's using his personal cell phone. It's also where when we talk with governmental bodies, that's why the policy comes into play. That burden is on them to know where to look. So.
Last question.
This question's for Tamara as well. On the cost issue again, if you're not sure whether or not your request is going to include the confidential information, can you strategically somehow in that request state that confidential information is not responsive to the request to prevent them from charging for that or redactions?
Yes and no. And if it's an entire record that they could exclude, so an attorney-client communication where the entire communication is, then yeah, that may save you some money. If it's something where no matter what, they're going to have to actually go through and mark it and redact it, those are things they could potentially charge for. That being said, in a cost estimate, one of your options is to narrow it, right? So it's not doing it beforehand definitely saves time, right? We're not going everyone having 10 days back and forth. But it's not that option is completely taken away from you if it happens, right? Because again, as citizens, you don't know sometimes what they have until we ask.
So John, I'm going to ask for your last thoughts and then I'll close. But in this moving forward, we're coming out of COVID. There's been a lot of things going on. We've got record, ORD requests being made to Tex AG. What do you see coming up next, and how can this, what we're talking about here today, help folks moving forward?
I think it's really important for citizens to stay engaged no matter what the issue is. Obviously, education is a big issue right now, but these are very powerful tools for everyday citizens to utilize. So, make the request to your government entities to figure out what they're doing and follow up with them, follow through. If you run into problems, please reach out to our organization, the Goldwater Institute, TPPF. My colleague Cameron is in the back. We have a nationwide pro bono network with 500 lawyers in it, so that if a records request is denied, essentially anywhere in the country, we can tap somebody's shoulder to get a little assistance with compelling production. If you're a Texas lawyer and you want to do some of this stuff, sign up for that. It can be really fun work. So there's resources available to you, and you're also blessed in Texas to have the AG's office sort of overseeing this stuff.
So as my closing emphasis, I agree with John and Tamara. I think they've done a great job with the discussion today, but these are powerful tools. They're here for you to use, or they're here to use in your practice, or here for you to use as a citizen. I hope today's discussion has been useful for you in understanding how these work a little bit more. I want to thank, again, the Goldwater Institute and the Austin chapter of the Federalist Society for co-hosting this, but especially want to thank John Riches and Tamara for their remarks and being panelists here today. So guys, thank you very much. And with that, we'll close.